evening and welcome to the new PI show. We're back for our third season and we're here to discuss legal cases involving personal injuries which we think are of national interest. I'm Harry Nowicki and I'm here with Tony Carbone, a personal injury lawyer, 25 years experience. You can contact us on the PI show and we'd love to hear from you. Emails, questions, comments, we really appreciate it. Tonight we're examining the role of a defendant lawyer and what role they have in personal injury litigation. Our guest tonight is Martin Smith.
Evening.
Martin's been a PI lawyer for 35 years and most of that has been spent as a defendant lawyer. But before that, Tony, we're here to talk about what's been in the news in recent times about PI.
Thanks, Harry. This week there's been a lot of stories in the paper about a senior and very competent Melbourne barrister who was rebuked and condemned for his conduct of two defences in two significant trials where there was a miscarriage of justice. The matters went to the Court of Appeal and the court ordered retrials in both cases at a very significant cost to the community and to the parties involved.
Tony, I think the role of a defendant barrister, it highlights a attitude in some cases of win at all costs, very aggressive, win at all costs. And I think they've got a duty to the court, duty to their client, and it's not easy to balance up those duties sometimes.
I agree with you, Harry. There's a code of conduct, I suppose you'd describe it as. That code of conduct, as you say, is a duty to your client, obviously, duty to the court, duty to the law. And if you're acting for a state agency or a Commonwealth agency, you have another higher set of guidelines called the Model Litigant Guidelines. If somebody breaches the code of conduct, what has happened is the Court of Appeal said go and retry the case again.
Well, Martin, can I just interject early in the piece? There's a perception out there that the role of the defendant lawyer is to minimise and to save as much money as possible. That's a perception by the general public. What do you say about that?
No, I don't agree with that. The defendant lawyers have a number of tasks. They're acting for an insurance company or a state agency. The first task is to identify some issues on the file that they get and to put an accurate estimate on the file. That's not an easy task, and the distinction I give to anybody who wants to understand it is if you're acting for a plaintiff, you're dealing with a real person. You've got a client who you can sit over the other side of the table from and have a discussion. If you're acting for an insurance company or a state agency, you're not dealing with the person, you're dealing with a paper file that you read, like a storybook, and then you've got to try and identify the issues out of that storybook and put some accurate estimates on it. You obviously need to seek further information. You don't get the whole story on the first look at it.
Well, there's also a perception out there, Harry, that the defendants deliberately delay cases and drag the chain and, to cheese plaintiffs off and also to run up costs. What do you think?
Oh, I think there's a changing development in that area. I think over the last 10 or 15 years, fewer matters have gone to trial. One lawyer told me recently that in their first year as a lawyer, they ran 12 jury verdicts, and that was the most the law firm had run. Now, most cases settled, before trial. I must say some defendant lawyers are better than others, obviously, in terms of being proactive, being able to talk at an early stage to assess a file. I think, Tony, your philosophy is to have an early preliminary discussion with a defendant lawyer to explore what sets them apart.
Yeah, the thing is this, Harry, more often than not, defendants have got paperwork that's flung around the place. The pleadings, which is the documentation setting out the respective cases and defences. Yep. And what I'd like, and what I think is important, is that we ring up the other side, which is the defendant lawyer, get together early in the piece and we start some sort of discussions, which doesn't necessarily mean you're at a point where you can possibly settle a claim, but at least you get things going and they're in the picture. You fill in the gaps, so to speak. I
agree with you, Tony. Look, it's changed a lot from, as Harry said, 15 years ago. Now they have alternative dispute resolution techniques. However, it's a bit of a story like Bob the Builder. Can we do it? Yes, we can. The story is if you communicate with the other side, if you set down a time frame, as the court does, to manage what has to be done, the discovery, the pleadings and all those issues which are legal issues, You can then move to having a discussion on a number of occasions and trying to resolve what those problems and issues are. That's being proactive as compared to a process-driven, reactive defendant's lawyer that just goes through the process and does nothing until just near the trial. Obviously, the proactive approach is the one to be looked at. There is no benefit to an insurance company having a case delay year after year. Let's not kid each other. It costs money to run a case, and the longer the case sits around, the more expensive it gets.
But Martin, just curiously, how do defendant lawyers estimate the cost of a case early on?
Well, the first thing they've got to look at is the jurisdiction and the legal issues, the injuries. They've got to try and assess what damages are. We know what damages are. We've discussed that before. What's the injuries? What's the injury worth? What's the effect on the person?
In your experience, how much are variations over the journey?
Every case is different, Harry. Every fact situation is different. Yes, there will be variations over the journey. The first estimate on a file is not the last estimate. If fresh evidence is put before a defendant solicitor, the first thing that you do is you read that evidence, then you report to your client.
But Martin, don't defendant lawyers more often than not lock themselves in early in the piece where they send a letter of advice off to their client, setting out the issues, liability, quantum, contributory negligence, all these sorts of things, and they find that it's very hard to backpedal. They lose face with their client.
I understand that. It's the art, I suppose, of a defendant's lawyer to leave that door open. Surely it can be prefaced on the fact that on the evidence that's before me at the moment, that's the way I see the file. If there's any fresh evidence, I will readjust the estimate.
So it's important that the plaintiff lawyers, in effect, give fresh evidence. That's often medical evidence?
Yes.
Or evidence about liability or witnesses about circumstances of an accident.
Right. And the other test in a lot of cases is credibility. Is the person telling us the full truth, nothing else but the truth, or are they only telling us part of the truth? A person can have their case fall apart if they're not telling the full story in their pleadings, in their affidavits, and other evidence comes out at court.
So, Marty, surveillance is a big issue, isn't it?
Surveillance is an issue. Telling the full story is an issue. Telling the plaintiff's lawyer, and then open and honest communications between the lawyers. I think it's best that everybody understands if the cards are on the table face up, everybody's looking at the same picture.
Marty, we're going on a short break on the PI show, so stay with us. When we return, we'll be back with Martin Smith, defendant lawyer, to discuss the issue and the role of a defendant lawyer.
Thank you.